We are live.
All right, good morning. We're back in Senate Judiciary on February 6th. We're taking up S-193. We have Ledge Council to talk about some thoughts they have on proposed edits. We're going to go for probably 30, maybe 40 minutes, and then we'll have to pivot to 209 to wrap that up. And that's about what our timeline looks like for this morning. Then we have the floor at 11:30. So, Ledge Council, the floor is yours.
Thank you, and good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, as Senator Hashim said, here to talk with the committee about some proposals from the Department of Mental Health regarding Senate Bill number 193. And this is the forensic facility bill, which I know the committee has talked about and gotten a walkthrough on. So had some discussions about it with Katie and with witnesses previously. Katie will be probably joining us in a few minutes as well. She's in Senate Health and Welfare at the moment. But so the plan today was just perfect timing. I just mentioned you joining us shortly. Okay. Yes. Yeah. I just realized as I was pulling this out that I hadn't made copies of the bullet points.
Oh, okay.
But I guess we can still kind of walk through them and then make some copies after. I did have
share my screen.
Emery made copies of the proposal itself. Yeah, that could work too.
Would you like me to do that?
Sure.
Sure. Yeah. Sorry.
So as we're waiting for that, I can throw out a couple of big picture things that you'll know because they're also right in the beginning of the DMH or AHS proposal. So everyone has this document, I think, the one with the colored highlights on it from AHS, the one that says AHS proposed edits and additions. And that's the one that Katie and I took a look at and had some thoughts for the committee to think about. I think the idea is, to the extent you may want to include some of the amendments that AHS proposed, or look further into some of the other ones, that we would walk through them to start with and give you some preliminary thoughts, and then the committee can decide which ones it wants to go ahead with and, or make some changes to, or whatever the committee's preference might be. So, having said that, on page one, maybe the highlights sort of show the proposed changes to the bill as introduced. So everybody see some of the colored highlights, for example, page one. The first one, like the first yellow one, which will bring up the first point that we noted as well, is that the evaluations that have to take place when a defendant's competency has been raised in a criminal proceeding. So currently, it's the Department of Mental Health that's ordered to conduct these evaluations. And the proposal is to shift that over to the Department of Buildings and General Services. And you would see that on page 3 as well. The court may order subsequent evaluations performed by BGS. So obviously that's something that we flagged. Weren't sure if the intent there, you may have already heard from DMH witnesses could have already talked about this, but the question is, I'm going to assume that it's something BGS would contract out for, as opposed to, I don't think there's any psychiatrists or psychologists there who would be doing it, but I assume they contract for it. But that's just something to note for the committee, that for BGS to be the department overseeing these mental health evaluations is something you probably want to ask more about, how that would supposedly work.
Again, why would BGS be the one?
That's what we were wondering.
A question for the department.
Right.
And as we flagged, you might want to hear from BGS as to what their capacity is to do that type of work.
Yeah, okay.
There was, I think it was Senator Bohosky who may have raised it last time, and actually she has her hand up, so maybe she's Senator Bohosky.
Yes, I was the one that raised the same question when DMH was testifying, and what they had said was that BGS, the general services aspect, tends to apply to a lot of contracts, but I definitely think we should hear from BGS because it certainly flagged for me the other day, and to get, still that seems strange.
Okay.
So we'll note that one, good one to flag. On the same page, another one that we flagged as well, as far as having some questions about you'll see, so the proposal is that, that the diversion program, which is run out of the Attorney General's office, be involved in these competency proceedings in the sense that you look at at least in my document, it's pink, but I see it might be blue in yours, subdivision 5 toward the middle.
Yeah.
Court may order a competency evaluation in a misdemeanor matter only upon a finding that diversion has been attempted and been unsuccessful. The rest of the yellow language is just a sort of a definition of what they mean by unsuccessful. So if we skip down to the bottom of the page at number 6, so that was misdemeanor. So for misdemeanors, there has to be a finding that diversion has been attempted and been unsuccessful before a competency evaluation takes place. And then number 6, for felonies, requires that the parties must first consider a referral to the adult court diversion program before the court orders a competency evaluation. So that's another one that we flagged, because these two things at first blush seem to be unrelated. Like why, how a defendant's mental health status for purposes of competency is relevant to whether or not they completed a diversion program wasn't immediately obvious to us. It also raises the question of, well, if the person is only going to come up, the evaluation is only going to happen if somebody, either the defense attorney, the prosecutor, or the court, raises the issue of the defendant's competency, because it's when that happens that the court would order the evaluation, right? So it raises the question of, well, the defendant is raising their somebody is raising the competency of the defendant to stand trial. How are they going to participate in diversion anyway? If there's already a competency issue, it sort of begs the question of how is that person going to even participate in the diversion program?
Eric, I agree with the point that you're raising. I think also when you're going through diversion, I think it's correct to say, as long as you successfully complete it, you don't have a liberty interest that's at stake. And so you don't necessarily need, the same level of competency to go through diversion as you would to speak and work with your attorney going through a trial.
Right.
I don't know if that's all that is correct, but it's just a thought that came into my head.
No, I see what you're saying. It's a good point.
And I see Senator Bohosky has her hand up.
Yeah, I had raised this yesterday in a slightly different way, and that was, diversion has to be voluntary, and if someone is incompetent, can they voluntarily engage with something? Like, do they, if they're not competent, do they have the capacity to consent, I guess is sort of, and I raised the voluntary aspect from a different standpoint the other day, but now as I think about it more, I'm also wondering if there's another layer to that.
Yeah, I think that's a fair question too. The competency hasn't been, or incompetency hasn't been established yet, but it's certainly been raised at that point. That's the whole reason that the diversion proceedings would kick in. So, yeah, if they were, whether or not there's been a legal determination yet, but if that person was incompetent, that's a fair argument that maybe they would lack the capacity to participate in diversion or agree to it or make those kinds of decisions. It also occurred to me, I don't have the answer to this, but it was just a question that occurred to me that, it is unconstitutional to try an incompetent defendant. So this seems to be saying that, so can you prohibit a defendant from even raising a competency defense if they don't participate in diversion? I don't know the answer to that. That just sort of struck me as an interesting part of the proposal. It seems to be saying that, the court can't can't order the competency evaluation until there's been a finding that diversion has been attempted and been unsuccessful. So it seems to kind of limit the defendant's ability to raise competency as a defense.
You're talking about section 6?
And 5, yeah, both of them. Actually, more so, well, I'd say 5 and 6. They're a little bit different because 5 is a strict prohibition on, ordering the competency evaluation until there's a finding that diversion has been attempted. Whereas six, I mean, it's similar, six says they must first consider, as opposed to a, an actual finding of attempt, an unsuccessful attempt. But it would be interesting to hear the kind of similar point to the BGS about hear from them. It's the Attorney General's office that oversees the diversion program. So presumably this would result in a lot more cases going to diversion. So it'll be interesting to hear the AG's take on that.
So I guess one question is, I mean, if a defendant is, for whatever reason, adamant that they want to take their case to trial rather than going to diversion, that is potentially where the problem lies.
Right,
Yeah,
right.
it would be, and I suspect it would be incredibly rare, but it's still a situation that exists. Yeah,
Right.
or it's still a possibility.
Yep.
And, okay.
And then, you're right, it might be rare enough so that, it wouldn't necessarily be something that would kind of rule out the proposal, because you just sort of wait and see if it ever, because it may never happen, so wait and see if it ever does come up, maybe, because it's sort of more of an as-applied kind of thing, rather than, necessarily a reason to not go ahead with that idea. But it's sort of an issue to have in the back of your mind, anyway. So that kind of brings us to, we were talking about the BGS, so I think now we're getting to the actual procedure 4815A, page 3, does that sound right?
That sounds good. If you're looking at 4815A, this is marking up sections of the bill as introduced. The concepts in the language that is being proposed by the department in A and B are mostly already captured in the A of the bill as introduced. So we're just flagging that. The significant difference is that this would include individuals who are being held under Act 248, which is offenders with developmental disabilities. So it's the inclusion of that population, but otherwise the addition of A and B is already reflected in what is in the bill as introduced under A, which is that a person would be in a forensic facility if that person is charged with an offense punishable by a life sentence. The person is not deemed a person in need of treatment. Again, that is a defined term. That's a standard in Title 18 for holding somebody for involuntary mental health treatment, and that the person has been found not competent to stand trial. So the addition here, I think, from the health department would, in addition to a person who is a person in need of treatment, also the inclusion of offenders with a developmental disability. So individuals who have not been deemed offenders with developmental disability under Act 248. Similarly, in the highlighted language on the next page, subsection C, that language is, for the most part, already in the bill as introduced under subsection B. And that is the concept that once the person is admitted to the forensic facility, the person is to be evaluated for competency to stand trial not less often than the shorter of every 6 months, or upon a determination by the facility's clinical director that the person is likely competent to stand trial. So that concept is already captured there. In subsection E, this is language about the treatment plan for the individual. I don't want to call it a treatment plan. That while the person is receiving competency restoration services at the forensic facility, there's a plan by the facility's clinical director. And then there is language in the bill that this could include medication. And then the department is adding this language in B, pursuant to the administrative process meeting the requirements in Cell v. US. We typically wouldn't refer to a case like that in statute, so the proposal, or I guess what we would flag is that, it might be more appropriate to use the holding, the standard that that case, stood for, instead of having the case listed there. I think it probably would also be easier for practitioners in the field who are trying to understand, when medication could be used if the standard was there instead of a citation to a case. So, just food for thought as we go through this.
Sarah North, sorry.
Oh, I'm sorry.
Yeah, Katie, I'm sorry, under C.
Yeah.
Where, I guess I'm a little confused here. This whole bill is going to confuse me as we move through it, I can assure you. Because,
Okay.
the facility shall cause the person to be evaluated for competency, staying trial no less than 6 months upon the determination by the clinical services director. Does that mean the clinical services director is the one doing the competency hearing, or they're gonna, because we were told the other day by DMH that these are like $4,000 costs for these, and we're doing every 6 months here. So who's doing that evaluation?
It just says upon the determination, so I don't know, I think that gives some flexibility for the service to be contracted out or for it to be in-house,
In-house, if they have one?
by the clinical services director or somebody who is supervised by the clinical services director. I don't think that language alone answers your question. I think that is an open question.
Okay, thank you.
Yeah. Then, is it okay if I?
Oh, yeah.
Okay,
Please.
so then we get down to subsection G, and it's highlighted, so that indicates that this is language being proposed by the health department. So this is, Department of Mental Health, not the health department. This is a significant change from the bill as introduced. Under the bill as introduced, there is this assumption that competency restoration continues until there is a verdict in the case, and you'll kind of see that in the sentence in subsection F. Competency restoration services shall be maintained until the person receives a verdict in the person's underlying case. However, what this language addresses is a situation where competency cannot be restored. So there's no assumption in the bill as introduced that competency can't be restored, but in subsection G, there's this language, well, what if competency can't be restored? Some things to think about when you look at this language, is that there's no, time frame for when a decision is to be made about whether or not competency can be restored, or there's no standard, in the language about, you know, like, if this occurs, we know that competency can't be restored. And also, who is making the decision that competency can't be restored, or how that decision made, that's silent in this language. So if the committee chooses to have, you know, some type of scenario when competency can't be restored, you might want to think about those points. Who is making the decision, under what conditions, or under what time frame is that decision being made? Is competency restoration attempted for a certain number of months or years, and then this option happens? So food for thought. Ooh, I should scroll up so you're following along. Sorry about that. Because the bill is introduced doesn't have this sort of avenue where competency can't be restored. It doesn't have a process in place for what happens if competency can't be restored. The language from the department gives a process that happens if competency can't be restored. That language mirrors or is parallel to language later on in the bill that applies to individuals at a forensic facility who are there because they were found not guilty by reason of insanity. In that section of the bill that we'll look at in a bit, there is a process by which, if a court finds that a certain standard is no longer met about the person's dangerousness to other individuals or the property of other individuals, there is an order of conditional release. This language is all borrowed from that language later on in the bill. And if the committee wanted to pursue this, it might make sense to sort of bring those two pieces together so we don't have duplicative parallel processes happening in different sections of law. Do you have anything to add to that?
Yes, I was gonna
Okay.
jump in on subdivision 2 at the bottom of page 4. I think this is something that can be easily remedied. But you'll see that the way the language reads now, the person shall be committed to the forensic facility unless the person establishes by clear and convincing evidence that the person's release would not create a substantial risk, et cetera. So it's shifting the burden to the person to prove that they're not that, rather than, I think constitutionally, the burden has to be on the state to establish that the person is.
Yes, I found that as well. Few US Supreme Court cases that highlight that. And so I
Yeah.
think it's definitely something that we need to change.
Right.
I think, never mind, yeah.
Right. Yeah, I'm not sure who in the process here is representing the state. Like, I didn't notice whether it's the state's attorney, like who's representing the state in these proceedings, but whoever that is should be the one who has to make the case. So, the state, but I think, as I said, that can be remedied, the language can be shifted so that, the person shall not be committed to the crime facility unless the state establishes by clear and convincing evidence.
One second, Senator Hosky has her hand up.
Yeah, in terms of who's representing the state, wouldn't that depend on what type of case it is? Like the state's attorney would represent in some of these misdemeanor cases we're talking about, but if it were some of the more complex cases where a life sentence is a potential sentence, in some instances, the attorney general might be the person representing the state. So wouldn't that depend on the case?
Yes, absolutely. And they do have concurrent jurisdiction in Vermont to prosecute criminal offenses, the state's attorneys and the AG for sure. So I think you can be general enough so that you're including both, but whoever that state actor is, for purposes of this, and as Katie said, the next section as well, should be the one who has to carry the burden of proof, I think. Does that make sense?
Yeah, absolutely. And I definitely agree. And I think the chair brought this up the other day, that shifting the burden of proof to the person would be problematic.
Right.
Senator Norris.
So I think in addressing this concern, under 2 on the next page, it does say that the person shall not be released until the court finds by clear and same wording, just starting with that second sentence.
Yeah, so though in that case, I think that is okay because it's the court that's making the finding, whereas in the preceding one, the burden of proof is on the person.
Oh, this is prior to being committed, okay.
Yes.
Okay, yep.
But I think you're right, I think the court, it's fine for the court there.
Language should just.
Senator Hosky, did you have any
Yeah,
thoughts?
my question on the language that Senator Norris just brought up is around the liberty interest. And is it typical that someone's liberty is held until there's clear and convincing evidence in their favor, as opposed to their liberty interest being assumed until there's clear and convincing evidence not in their favor? Because the way that that's worded, they are to be held until there's clear and convincing evidence that they shouldn't be held. Whereas typically for liberty interest, they should be presumed free until there's clear and convincing evidence that they shouldn't be. Does that make sense?
Yes, and I think you're correct, that for example, in the involuntary commitment statute generally, the finding and that a person is in need of treatment, in other words, a danger to themselves or others, has to be that the person, or they can only be held if they are found that they are a danger to themselves or others, not that their release wouldn't cause a danger to themselves or others. So I'm not sure if that's necessarily a constitutional requirement, but I think you're right, it's more typically phrased in the way that you pointed out. Does that answer your question?
Yes, it does. And it sort of is a flag for me that it's a shift away from how we would normally do things and possibly just a flag.
Yep.
I may shift off that topic. I had one point that I missed, I think related to Senator Norris's earlier question about assessments. If you look at the top of page 5, there's language from the department in subdivision 3 about the person being reassessed by a court every year. That would just automatically happen. And in subdivision 4, the individual themselves who's being held could seek discharge by requesting a court for a forensic risk assessment. And that subdivision 4, it's very prescriptive about what a forensic risk assessment would entail, the type of information that a court would be considering. It's looking at the person's history and of dangerousness, present dangerousness, a description of tests employed to get these results, the examiner's findings, the examiner's opinions as to whether the person would create a substantial risk of bodily injury to another or serious damage of property to another if released. But that same level of specificity as to what an assessment would look like is not there in subdivision 3, which is sort of the annual reassessment of whether the person should continue to be held. So that's just something to flag, like what are the standards that we're looking at when somebody is reassessed annually? Should they match when the defendant or themselves is asking to be considered for discharge, or is it a different standard? We don't know that from this language, so something to think about.
See, Senator Boski has her hand up.
Yeah, Katie, I have a question for you about this section, but then there's also some other pieces that I actually don't think are in this bill. I think are in a House bill, and that is where HIPAA comes into play with what information can be shared through these assessments.
I have to think a little bit more about this, but I think what we have to think about is this entity a covered entity? And the way it's set up, housed under the Department of Corrections, and it's not medical treatment that's being provided by DMH or a medical facility under contract with DMH, I think that would sort of govern whether or not HIPAA applies. So I don't know how the program would be set up, if it would be a medical program, but again, being set up in DOC, being very specific that these are not individuals who are persons in need of treatment. So they're not there for medical care, they're there for competency restoration. Kind of governs that analysis. It might put it outside of HIPAA, I guess is what I'm saying. I'd have to think a little bit more about it.
Yeah, I'm not sure if it's a complicating factor that DOC is under the Agency of Human Services and.
That's the point. Yeah, because AHS is a covered entity.
Mhm.
That's interesting. Yeah, I'd have to think more about it.
Okay.
Okay. Do you have anything else?
Nope,
Okay.
I'll set, thanks.
So if you remember when we first walked through the bill, there are 2 populations of individuals who could potentially arrive at the forensic facility. The section that we just walked through were those folks who were not competent to stand trial and who were charged with a offense punishable by a life sentence. So section 4819A of the bill is the second population, those individuals who are acquitted not guilty by reason of insanity for an offense that's punishable by a life sentence. So some of the points we already made with regard to the previous section are going to apply here. That's why we don't have a lot written down. But again, the concepts in DMH's A and B are largely already covered in the bill as introduced under subsection A, with the inclusion of the offenders with a developmental disability would also be outside the scope of who would be in a forensic facility. So the same language that's being proposed by the department for individuals not competent to stand trial, or that same language is being proposed here. Again, we have a similar process and standard for holding and releasing somebody who's being held at a forensic facility. The conditions of release are the same. So there might be a possibility of combining those two sections to not have duplicative language. I'll let you talk about the burden of proof.
It's the same language as you saw in the previous section, so whatever, if you decide you want to correct the language in one place, just make the same correction in the other to clarify that it's the state that carries the burden of proof there, not the defendant. Or perhaps, as Katie was saying earlier, you may even combine both of these rather than repeating it twice, but I mean, the whole separate sections are very similar, so that could be where it lands eventually. But either way, consistent.
And then, I don't know if you've heard from DOC about this proposal yet, but we just have flagged that as they would be operating the facility, and it would probably be important folks to hear from at this point.
Yes. Anything else from you folks or
No, I think that covers it for now.
committee? Any questions for Ledge Council? Well, I know we have, I think Karen Barber on the Zoom, who we do have 5 minutes. 5 minutes, I think. We do have 5 minutes if you just wanted to provide an initial response. And while things are still fresh in our head, and then we can provide additional time next week for more substantive discussion about your response.
Absolutely. Thank you for the opportunity. For the record, Karen Barber, General Counsel for the Department of Mental Health. I first want to thank Legislative Council. I know we sent this really quickly. I had sent a companion email trying to outline what we were going to do or trying to do, because we don't write statutes. So I'm really glad they caught all these things. It's super helpful. So I'll try to just quickly touch on some of the concerns that were raised. In terms of BGS, I think it'd be helpful to understand what DMH does for these evaluations. All we do is set them up. So we contract, we don't do them. We don't have folks that we on our staff that do them. We simply get an order from the court. We email the parties a Teams link. That's all we do. We just arrange for them. So there is no expertise needed. It's really just an administrative task. And as we mentioned yesterday, BGS tends to hold bigger statewide contracts that lots of different departments and agencies can pull from. The idea behind this one was that the state's attorneys and defender general are having to contract separately outside of our contract, and they're negotiating different amounts for those. We are able to negotiate better rates because we do so many of these evaluations, and the idea is that the state as a whole would negotiate a contract with better rates for everyone that they could pull from. And again, there is no expertise needed to do these evaluations. It's simply administrative. That answered that. Any questions on that?
I just want to clarify that there's no expertise needed to negotiate the contract. I would assume there's absolutely expertise needed to do the evaluation.
Yes, no, it's really just negotiating different rates. The contract already, as is, lays out what we need, and then I assume the state's attorneys and defender general would add what they need. Generally, statewide contracts, the different departments work with BGS to make sure what they need is in the contract, and then BGS kind of holds it in and does the rates. For diversion, this is a good question, and I had thought about raising it yesterday, but I didn't. There is a difference between competency to stand trial and competency to seek treatment. I think, Chair, you touched on this. There's no liberty interest implicated when you're not going to trial. So there are different standards, and I think we can have other folks come in and talk about how they do this in other states and how they differentiate between the ability to engage in treatment or not go to trial versus actually stand trial. We do this all the time, right? Just because you're found incompetent doesn't mean you can't consent to treatment, doesn't mean you can't consent to medication, can't mean people are signing wills, they're signing advance directives. So competency to stand trial is such a limited thing. It really doesn't implicate the competency to do a lot of other things. So I just kind of wanted to flag that, and we're certainly happy to have more testimony on that piece. In terms of who's eligible, I wanted to just flag this because it's a nuance that Katie is correct. The way the language is written now, it implicates anyone who would come under DMH custody. The reason we carved out order of hospitalization is because there are individuals who would be under an order of non-hospitalization, who would also meet that very general definition that we actually think should be eligible for the forensic facility, because again, an ONH is not, they wouldn't be necessarily in a secure facility. And so it still leaves open that someone would be in the community in a non-secure location. So that is the reason why we changed that language and we added specifically order of hospitalization. And then into the determination piece, someone raised this as a question later on in a different part. When it's talking about DOC setting up this facility, it specifies that DOC must have a clinical services director that runs the forensic facility. So that piece is referring to that. It's kind of confusing because things are out of order, but that's who that's who I think that was referencing to. In terms of why we added language around not being able to restore competency, one, I think it's just the reality that not everyone is restorable, especially folks. There is something called the Slater method for folks with intellectual and developmental disabilities. It's much less successful than, say, in mental health. Someone with substance use has different needs. There's also a lot of national litigation around not being able to just hold someone indefinitely and try to continue to restore them to competency. I think excellent point. We didn't flag any timelines around what that would look like. So that is definitely a needed piece. But that's what we were trying to address there, was kind of looking at what other states are dealing with in terms of needing to make sure that we put a time limit on that. In terms of the burden piece, that is language that was already in the bill. DMH didn't draft that language. Whatever you want to do with the burden, we don't have a position on. Really, what we were just looking at is, you know, how someone was getting into the facility and what they were getting in terms of treatment wise at the facility. And then I did just want to flag, and I kind of put this in my notes and talked about it yesterday. So the language we proposed doesn't have the victims notification pieces, because I didn't know that we were the best people to do that. I flagged where I thought it would fit in. I want to make clear, though, that we do think those are important pieces. Those just weren't in our language because really it's not our thing, but we want to make sure that's in there, and just to raise that we support putting language about victims' rights in there. We just didn't have that. So I think those were the really quick things I wanted to touch on while everything was fresh.
Thank you. Appreciate it. Committee, we're pretty much at time, but does anybody have any super quick questions for Karen? Okay, great. Thank you. And
Thank you.
We'll definitely be in touch with Emery as well and schedule some more time next week so we can take a
Okay, wonderful. Thank you so much. I appreciate it.
All right, committee. We're gonna switch gears now to S209. Thanks for coming in.
Thank you.
Yes, there is.
Are we on 1.1?
Around 1.1, I know our decision point is around subsection B. I think we're going to be talking about whether or not, I think we're going to be getting a new copy so we can make that decision as to which version. Those are mine. Do you need Emery so you can use the screen? Or?
He took care of it before he left. Good morning, Rick Sagel with the Office of Legislative Counsel, and Mr. Chair, yeah, how do you want to proceed with the language?
Well, that is the only decision point that I'm remembering. I don't think there were any other pieces where we were at odds as a committee. Just double checking my notes here. Yeah.
Just an old one, or
What's that?
just an old one?
Yeah, that's as passed or as introduced.
As introduced.
So I guess I'll ask the committee where we are, just one second, are you looking for a copy?
Yeah.
You want that?
Do you have your folder?
I should have it. I should have a lot of things.
It's right.
Well, thank you.
I got it.
So we're at the decision point of whether or not we're keeping in subsection B, which is lines 6 through 8 on page 2, draft 1.1. And I know this was one that we spent a lot of time back and forth on. Is there anybody who wants to start the conversation on this? Senator Norris and then Senator Hosty.
Yes, as you well know, I've had a problem with B in its entirety since we first looked at the bill as introduced, and as we're looking at it now, there's been several things added to this, but I think that the state of Vermont presently has over 2,200 buildings that they're in care of, one way or the other, through leases or whatever else. And we also have 252 municipalities and town clerk's offices and municipal buildings and whatever else. This is the only portion of the bill that I have a problem because I think it's too broad. I think it's too vague. I guess at any point in time we could identify, even with the new section, as to or attempt to identify a building controlled or a political subdivision of the state. I think this particular thing is just way too large. The rest of the things I can go along with: the schools, the hospitals, the facilities, the daycare facilities. Even if you look at the educational definitions, I mean, those are vast too, as far as what can be, but I want to maintain it that our schools and our hospitals and our university facilities remain a place where people can go safely and so on and so forth. But I just think that this is way too broad. I'm not comfortable putting in here. And basically I oppose such a different beginning of having section B in that.
Senator Hosty.
Rick, is my understanding correct that the only aspect of this bill that has been challenged and upheld is the portion on state, county, and municipal buildings because New York did something by executive order and won the challenge?
So mostly, so yeah, New York City has an executive order that applies to state buildings and prevents civil arrest around state buildings in New York City. The courtroom aspect has also been litigated, and that appears to be constitutional. But correct, the other locations have not been litigated so far: churches and hospitals and educational facilities.
So at this point, Section B is the only part we know is defensible, and courthouses.
So defensible meaning that, yes, the district court in New York said that there's a sovereign interest in state buildings, correct?
Okay,
But,
and the way that we've changed the language in this draft does narrow what that means fairly significantly, yes?
significantly, that's kind of up to maybe personal opinion. I think we made it clear that the salt shed is not where governmental services are provided. And it's also clear that a park would not be included, or a pool, because it's not a building necessarily. But I think it's also, you could narrow it some more, but that would be up for discussion, how you want to do that.
And then my other question for you from a standpoint of sort of being part of a community is, what rights do people have to government services?
Are you talking about constitutional rights or just in general right to access government services?
Both.
I'm failing to think of any, the right to vote is one that's actually enshrined in the 15th Amendment and 19th Amendment. But I'm wondering, the right to enter the state house is a limited right, because even in statute, if someone is a public disturbance or is threatening, they can also be removed from the state house. So I don't know if there's a constitutional right. Also, the open meeting law, you have the right to be in a public body unless there's some kind of issue to it. So I don't know if there's a constitutional right to receive government services or be in a government building. But certainly the argument is that the state has more sovereignty over that location than the federal government would. I think that's the argument that the district court made in that one case.
I appreciate that piece. I feel pretty strongly that this should be included. I think, people being able to engage with government and get the services that government provides is pretty critical, and worked to really limit the language so that it only applies to those instances. And I also think, given that the executive order in New York that applied to all state buildings, presumably including the salt sheds, has been upheld, is an additional factor in why this makes sense and should stay.
Do you happen to know whether or not, Rick, whether or not the executive order extended to state buildings in whole or in part, or was it just in whole?
My understanding was it was in whole, but I can, if you give me a few minutes, I can check that.
And how would you define a state building that's controlled in part?
So this was language that my colleagues in Devlin helped structure. My understanding is that there are times when the state does not own the building, that it might lease a portion of the building to handle government services. So the in part language was intended to ensure that those buildings are also included in the definition of a state building that is controlled in whole or in part by the state, or a political subdivision of the state.
So would a private entity that's renting state property, would that property be considered controlled by the state in part?
A private entity, say it again, sorry.
So if a private entity is leasing state property, and that private entity is doing whatever the private entity does,
Right.
that building is controlled still in part by the state, right?
That would be my understanding, yes.
Can I ask a follow-up to that question?
Oh, yep, yeah.
The instance that the chair is putting forward, that private entity would not be providing governmental services, though, correct?
A building in which, so if in that building that is leased in some way by a private entity, if in that building there is some part of that building where government services are being provided, then I would argue that it would be included in the exemption from civil arrest.
Okay. Because sort of on the other side of that, what came to mind was like the DMV in South Burlington, which is at a strip mall. So we want the DMV protected, but going to the furniture store next door would not be getting governmental services.
Yeah, so yeah, I'm thinking about the term building. I think it's potentially confusing. Is a strip mall one building, or is it, separate? There's one kind of building, right? So that would not be the intent of the law, right? But I think that you could argue that it is part of the same building. Sorry, I can't give you a more clear answer, but that's because there isn't one probably.
Well, it sounds like a lot of this can be challenged, okay? And I still approach this as a very gray area. And we don't have anything concrete other than, I don't know who did the executive order in New York, but that was our new mayor, whoever that may have been.
Yeah, I'm pulling it up, yeah.
Okay. But we're running into I think, I know what the senator is looking to do here, obviously, but I think we're running into an area we really should take our time on. We shouldn't be exercising this right now. I think it's just too challenging and too broad.
Any other senators have thoughts on this? Yeah. I'd like to give an opportunity to see if there's other folks who wanted to chime in.
Yeah, I'm kind of with Senator Norris on this one. It's very hard for me to define that, because to go back to the salt shed, the town of Melton offers a pile that you can go get sand for your driveway walkway. That's a governmental service. It's, so it's just that, trying to find that definition. And then with a building in which controlled in whole or in part, in which governmental services are provided, would that be extended to a subcontractor working on behalf of the state? So I'm thinking of the bill we just had, state subcontracts evaluations. Would that also be covered under this?
So I was reading while I was
Sorry.
talking. No, that's on me. If a contractor is providing government services,
Yeah.
what's an example that you can think of?
So like in our forensic facility bill, they have to subcontract out for the evaluation piece. Is that covered?
Yeah, I mean, to me, if it's in a building that is controlled in part or whole by the state, the government service to me doesn't matter if it's a private entity or the
Or a
state.
state.
Or close, so yeah, right. To me, that would be included.
Yeah, I mean, the broadness of it, I'd like to be able to narrow it down, and I'm in support of the other areas that are in this bill. It's just the vast array of the state or government buildings, excuse me.
Senator Bohosky?
I mean, I think if the concern is the clearness of the language and the most defensible language, it would make the most sense to just do what has been upheld in New York and have it apply to all state buildings. I was working to try to compromise by narrowing that, but I feel like if the concern is how vague it is, then let's just do what New York did and was upheld as constitutional and have it apply to all state buildings. You know, I brought the narrowed list in the vein of compromising and trying to narrow that list.
Oh, sorry.
No.
Well, no, you have new information.
I have an update on the executive order, if you care to see.
Yes.
In fact, let me share my screen just so you can see the language. One thing, it was a state governor executive order, so not a New York City order. I misremembered that. It was Governor Cuomo back in 17 or 18. Of course, he's no longer the governor. So I just want to show you the definitions here. State facility shall mean any building or any part thereof owned or leased by any affected state entity, and that includes all agencies and departments over which the governor has executive authority, and all public benefit corporations, public authorities, boards, and commissions for which the governor appoints the chair, et cetera, et cetera. So again, New York maybe uses different names for the way they structure their government. I don't quite know the way New York labels agencies and departments and how much executive authority the governor has over those. But this is the order that the district court upheld.
It's a public benefit corporation.
Again, in New York.
Yeah.
Right, it's gonna be different.
So that may or may not apply to Vermont, is what we're saying, just the way the terminology they're using here, because their government is set up differently, run differently. You see that may not apply to government entities in Vermont, is what you're saying?
Well, the way that New York defines, their agencies and departments, I don't know the governor's authority in New York and what they label. Is it just the executive branch, for example, in New York? I don't know. So I can't speak to how broad this actually is.
Could you just scroll to where the prohibition section
Yes.
is, and then Senator Bohosky has a question?
It's this next page here. So civil arrest by federal immigration authorities may only be executed within state facilities when accompanied by a judicial warrant or an order authorizing them to take into custody.
Thank you. Senator Bohosky?
Yeah, so I understand, Rick, that New York may define things slightly differently or do things slightly differently, but the underlying decision that the state does have the authority to say what happens in their state buildings would apply to Vermont, even if we use different words to define that.
Correct.
Okay.
Yeah. I mean, I have reluctance of removing this. At the other hand, as the chair, I'm trying to make sure that whatever we do get out, at least there's some consensus, and we're also able to see it through all the way through the House and then back through here and to the governor's desk. I mean, we have state buildings, we have our right as a state to exercise our sovereignty over those buildings. Fortunately, this bill is very expansive, more so than what previously existed, with just the prohibition of courthouses. We're still keeping the traveling to, entering, remaining, and so on and so forth for all of the new places that we're adding. We've got polling places in there. So,
It's
yeah.
quite vast.
It is expansive,
Yeah.
but, I mean, at the other hand, it is our right to exert our sovereignty over our own buildings. So, I mean, but again, I also want to see whatever we pass out of here have some degree of consensus and a actual likelihood of becoming law instead of dying in the House or dying on the governor's desk. So I'm reluctantly fine with removing that section and not touching anything else. That's my, if that's, yeah, well, that's my opinion. Senator Ruth.
So just to echo one point that you said, it is a very expansive list. I was initially worried about that because it's amending a statute that was successful to protect court proceedings, people going to and from. One worry I have is that we would make the list so broad that, it might conceivably endanger that piece. But this is kind of deja vu for me because we had a very similar discussion when I put in a bill in order to prohibit firearms, thank you so much, in 3 different locations: government buildings, childcare centers, and hospitals. And around this table, we talked about it. We came to the exact same argument over government buildings, that there were simply too many of them. There were unanticipated buildings, the salt shed being the one we always come to. But in the interest of moving that one along and making it law, it is now against the law to bring a firearm into a hospital. But we had to drop childcare centers and government buildings. Childcare centers are still protected here in the things that we all agree on. So again, I would reluctantly go along with dropping B if we keep everything else, understanding that it's a very difficult thing to try to limit the federal government's access and ability to operate within the state. So I guess I come down similarly to you, Senator Ashe.
Just quickly, for the record, it's not just the federal government, it's civil arrests entirely.
Yes,
And
absolutely.
it could incidentally affect the federal government.
Well, correct.
Senator Host.
I just, again, circle back to the fact that, yes, this is an expansive list, and the only proven part of it that is defensible that we are adding is Section B. The rest of it is up to question as to whether or not it would stand up under scrutiny. And so for me, to take out the only part we know we can do seems ludicrous, rather than leaving in the narrowed list. And if we're worried that the language doesn't match, we could revert back to all state buildings. But this is the only part that has held up to scrutiny in it that we are adding. Like, I know courthouses has, but that's already law. So I think it's frankly ludicrous to not do the one thing we know we can do. And when I think about the services people are accessing, whether that it would have a chilling effect on them accessing, it's services like Reach Up, it's services like DCF support, it's services like potentially going to one of the buildings to do an immigrations and customs interview. Like, these are the services that we most want people to engage with. And this is the only aspect of the bill that we're adding to law that we know is defensible.
Well, thank you. I think it's, I get where you're coming from. I think, however, it's ludicrous to send a bill to the House with a 3-2 vote, knowing it'll die and we won't be able to create these protections for places like schools, churches, polling places, and so on, and throw away all of the work that we have done. Senator Norris?
No, I'm good with that.
Well, I would entertain I don't know if I need a motion for this, but
You need
I
a
think-
draft, a new draft.
Draft.
Yeah, so I have a draft 2.1, Mr. Chair, if you want to briefly see it.
that would be great.
That, all it does, from the previous draft is remove, make sure I have the right one here. Is subdivision B on page 2. So draft 2.1, I believe, should be on the committee webpage. Again, the only change from the last draft, the 1.1 amendment, is on page 2, the removal of subdivision B, which was previously the government building exception. So now B is polling place. Everything has moved up one subdivision. No other changes to the bill from the last amendment.
Any questions on this new draft? Senator Borowski?
I don't have a question, but to your point that all this may be for naught, everything we are adding may be ultimately challenged and determined that we can't do this. The only thing we can for sure do is government buildings. So if we pass this without the thing that we know we can do, it all may be for naught.
So it's my understanding, the sense that I'm getting is probably have, going back to what we did for 208, probably a 4-1 vote for the amendment. Then would it be correct to say that if that amendment passes, we're unanimous in our support for the new draft?
I am.
So I would entertain a motion then to vote out favorably the amendment. A motion to amend the bill.
Yes.
I'm relying on you for this.
Draft 2.1.
Oh, sorry, Senator Norris?
I'll make that motion.
Oh, any discussion? Please call the roll.
Senator Norris,
Yes.
Senator Baruch,
Yes.
Senator Matos, yes. Senator Bielski,
This is the motion to remove the one thing we're actually able to do.
this is the amendment.
Okay, no.
Senator Hashim,
Yes.
4-1-0. Now,
So now it's been amended. And now I would entertain a motion to vote out version 2.1, right?
You didn't need both, Mr. Chair, just the one that is.
that was actually that was
Yeah,
a question I
that's-
had before, because
No.
we're amending 209, we're striking.
You're adopting the report of the committee to adopt draft 2.1 of the amendment, of your own committee amendment to the bill.
But then we don't have to vote it out?
Well, as a committee, you have adopted, my understanding of what just happened was you voted on the report of the committee being draft 2.1. At that point,
Well, I think we're trying to have two votes.
We voted on it, on the amendment, because
Right.
it was a strike all, right?
right,
And now we voted to
As
amend
amended.
209, now
Just
we're
send it out
voting
as amended.
as amended.
I've never been a part of that type of procedure in a committee,
I think-
but I know on the Senate floor,
So I feel like it's all I think it's clear what we're doing.
the Senate floor, there will be a vote.
No, we often, and Senator Sears would often, make that motion as amended. So we would have two votes. I think you only need to report one.
Yeah,
The one is gonna be
Yeah,
as recommended, but
yeah.
all right, so
I'll double check with my staff to make sure that's what
I'll check with our staff as
Yeah.
well.
to make sure we're covering our bases, since it's what we did earlier with 208, I'd entertain a motion to vote out favorably, draft 2.1 of S209. Senator Booth? Senator Booth needs to do that. Please call the roll.
No discussion.
Any discussion? I'm gonna get it right sometime. No, okay.
No. Senator Norris,
Yes.
Senator Baruth,
Yes.
Senator Matos, yes. Senator Vihovsky,
Yeah.
Senator Hashim,
Yes.
5-0-0. Which is the vote, I believe, that will go in the calendar.
Yes, yes, that was your vote to adopt this. Yes. And pass it out of committee.
And who wants to report this out?
You might have just walked out, I'm not sure.
Well, we'll figure out a report.
Just make sure you let me know.
Okay.
Yeah.
Let's do
Thank you.
Thank you.
Thanks, Rick.
Appreciate your flexibility.
Oh, anytime.
Are we?
Yeah, we are